Hi, JD4K family. How's everybody doing out there? Anyway, so I had promised to do a show on law. So today is going to be on family court procedures. Um, as I stated, I have two separate shows. So tomorrow I'll be live in DR, where I'm at right now. Look at that beautiful ocean out there. Um, with My Truth Real Talk, and it will be on Boundaries Part 2, with the workplace and your supervisors or employers, something close to that. But we're basically working on family court procedures today. A lot of people need to realize that when you have a family or a situation, sometimes things get to a point where you got to go to court and file petitions. So I'm here to help assist in that in some form or manner, or at least to familiarize you with it and what's ahead when you do go to the court in a family matter. So first step will be to file a petition. Mostly people file petitions for child support, custody over children, or temporary order of protections. Those are filed initially by a person. A permanent order of protection is usually filed afterwards if it becomes so serious that it's required to be done. And these things are done based on family situations. So let's say we go to child support first. So you're filing a petition in the courthouse. Make sure you're at the right court, that the venue is normally from the person that's filing the petition, usually the petitioner or the plaintiff. You can call that person, would be you if you're filing the claim. Sorry, I have no water and it's very hot out here, but excuse me. So the petitioner or the plaintiff is the person that files the petition um, for child support, and the responder is the person that responds to it. In this case, we don't call them defendants because unless it's a criminal family offense. So, so the respondent is obviously the person that's going to respond to it, to the action that's taken against them. So we start with child support, and you file this claim in the courthouse. Please read thoroughly, because your case could be thrown out if you don't know what you're doing. If you need an attorney, please go seek one. If not, then it's not hard. It's basically self-explanatory. They'll give you the forms, look through it. The caption will be stating the venue on top and which court and what state it's to take place. That's really important, that you put the right person on the top, which would be you, the plaintiff, versus whomever. All right. So now that we get through past that, this then gets filed, and after it's filed, you'll be issued, for child support, you'll be assigned to an actual, not, it's basically not a judge, it's a hearing officer, and they're called, oh my God, I'm so used to working with judges. Hold on, because I have so much information here. That's it. A referee. So sorry. And this referee is actually an attorney that was appointed by the court. Is not the actual judge. They may act like one, but they do matters that aren't as serious. Putting it in layman terms, they're not as serious as a custody battle would be assigned to an actual judge. So you will get a referee that's an attorney hearing officer. That job is to actually gather information from you on evidence of your income and whatever it is that you need to file your case against the person, who will then come to court, be, be called to court, and they will gather their evidence of income, and then they will work out how much percentage that of that person's income will be taken out of their check weekly, I believe it is now. I'm not sure. I haven't worked in family court in years, but it used to be weekly. It might still be the same. You need to ask either the person, the attorney assisting you, or a clerk in the court, what, or the judge him or herself. Would it be weekly or monthly? That's on you. I'm not sure how that works, but those cases are done that way, and a referee is assigned to that. Make sure that this referee knows exactly what you ask, and that it's implemented in the guidelines, and they'll tell you if that's what they can do for you or not. On a custody battle, then there's a judge assigned to your case. And custody battles are usually when the custodian person is parent is chosen as the person to take care of the child, or children instead, or you can have joint custody. That would be a decision up to you. If you want to have the judge make that decision, then it will be done that way as well. But I prefer it if two adults get together and speak about it, and you want joint custody, then it becomes joint custody, and not something like, well, I want the child support, so I'm going to take custody of this child so that I can get your money. This is a game that's always played in court when the whole idea is to have the child um, taken care of by both parents in a humanly, you know, in in a way that they deserve, I should say. Because too much fighting around children is disgusting. I've seen it when I worked in the family court, but I do know that it's best that you do come to an agreement together. You can even sign an agreement in court, and when you do come to an agreement, it's better than having the judge make the decision, because then it might hurt the child, and you want to put the child first. I don't care what happened between you partners or husbands, wives, but children need to be put first and most of all, to to so that they're not going to live this for the rest of their lives of how you treated them during this process, because they won't forget. As I stated in my other video on child support, if you go back, you'll see it. They're not going to forget anything when they become adults. That's when you're going to realize your mistakes that you've done at that time, and you want to rewrite them. They can't be rewritten. So it's smart if you just do what you need to do to get this taken care of in a smart way, for the child's sake in any circumstances. That's what's most important. Now, when you're writing a plea in court without an attorney, take note that the judge will be reading the decision, reading the reason for the court to interfere in whatever you request. So if the judge feels like this is outside of child support, that your request has no merit, then it won't be heard in the court. But usually family matters are heard, but it can't be frivolous. Like if your boyfriend or girlfriend slept around on you and now you want to slap them with a order of protection overnight. I mean, these are games that people play all the time, and that's not going to happen. A judge is the truth finder, so they're going to want to know the truth with the two people in front of them, so that they can decide and make that decision for you. But if you want to play games with the court, you'll find out that it's not going to be that easy. Okay, you can do so and try to may get away with it, because I've seen that, but in the end, it's not going to work in your favor. So please don't attempt to come here and play games if it's not serious, and are you being abused or not abused. Don't use it to prevent someone from being with other people or seeing their children, or whatever the case is that you bring these frivolous cases to court for, because that's not what the court system is here for. And I'm only speaking for New York State Court, because laws are different in every state. Okay, so, and I only know New York State Court. That's who I work for. So as I was stating, the they're not here to play the game. So make sure you're writing your pleadings, if you're going to sign to it at the end of petitions, and you're going to be held up in court of law for it. So you better know what you're doing. Or, as I stated, get an attorney. It costs money, but for the basic first step, you can do it on your own. A court clerk will be there to help you adjust and assist in this. They can't give you advice, but they know the procedures and the filings and paperwork. That's their job, to help you assist in the clerk's office or the general clerk's office, or whichever. Wait, in family court, it's different. That's civil. I'm not sure what the office is called, but I'm sure it's called the clerk county office, where you start the beginning process to file petitions in family court procedures. Um, okay, so as I stated, when it gets more serious with custody battles, you will be signed in a judge, and it's better that you get an agreement with your spouse or your partner or ex-partner on that decision of agreeing together. If they can't, as I said, come to an agreement, then the judge will then therefore take over and make the agreement for you. Whoever has to pay will have to pay, or whatever decision is made is final at that point. However, if later on things change and you want to go back to the court to change something, because these children are going to be taken care of till the age of 21, and at this point, if they're in college, it can be up until 25 now. And so when you talk about that, there may be changes needed later on as they grow older. So then you would go back in and file a modification to the child support, or to the custody, to change something, to modify it. That's what a modification is, to modify the court order that was given to you previously or against you previously. Either party can go in and do a modification. If the petitioner slash plaintiff wants more money, they can go file a modification. If the respondent or slash defendant wants to stop payments or anything they want to do, reduce it, they can file a modification. That's what that is for. So always remember, the word modification comes from modify, and then you'll have an easier time in court when you really reduce things to not making it so legalese, but more layperson's term, which means non-attorney basics. It's very important that you don't make it too hard on yourself if you want to go forward pro se. So, and there are filing fees. I would not know, but you can go on the court's website, newyorkcourts.gov, and you'll find what the filing fees for each court and for what criteria, whether it's outside of family or not. You will find the filing fees there. Because I don't have them here with me, so I'm sorry. But those can be researched. Okay, so, and in cases of juvenile delinquents, which we call juvie cases, once your children get older, outside of child support and everything, some children get in trouble. And so there's new laws that have changed on children under the age. Delinquent cases, juveniles are under the age of 16. So they won't be tried as an adult, but 16 and over can be tried as an adult and held responsible for their actions, depending on what that case is, a misdemeanor, felony. They can be tried as adults now. So depending on the offense, juvies will be tried in court and criminal court, in the local criminal court, and not family court. Under 15 and under, you if you do an offense as such, felony or misdemeanor, you will be tried in the family court jurisdiction. So just make sure you don't. This took effect of October the 1st of 2019, so that now children over the age of 15 are considered adults, and will be sent, depending on the crime, to a criminal local a local criminal court where they did the crime, usually. And if not, then they will be taken to a family court where they either reside or, yeah, where the venue, where their venue of residence is. So, or county where they reside. Like, let's say it's the Bronx, you'll go to the Bronx Family Court. If it's in Manhattan, you're going to go to the Manhattan Family Court. So, these actions are taken against juvies because we have to, even though they're kind of rough, we have to show these children that you can't do these kind of things and get away with it. But a lot of opinions have come that they shouldn't be sent to criminal court. So they actually, it depends on the offense now at the age of 16 and up to see if they really want to actually put them in a local criminal court and be tried there with adults, which can be dangerous. So, I think, what's that show called? Scare Tactics? Not Scare Tactics. I think it's called that, where you scare these children enough. That's probably why this law has changed, so that they don't commit it. Either way, there's a program. Scared Straight. Yeah, that's it. Thank you, honey. There's a program for PIN in the family court called PINS, with person in need of supervision, and sometimes the adults, parents, grandparents who have custody of the children or their grandchildren may need that program. The children can be a harm to society or a harm to. Oh my God, it's a big roach. Ah, oh, only in DR. I can't. I can't. Okay, so sorry for that. Oh wow. Right on your head. That was. Did you get it? No, he's right there. All right. So okay, so there it is. Let's get a picture of the beautiful sea then. All right. So basically, getting back on the question, PINS is for any parent, adult, grandparent in custody of a child or custody of their grandchildren and in need of supervision of children that are in need of help in any form or manner, or are a threat to society or to themselves, will be put in this program either by an individual, by the police if needed, by the parent or grandparent, or can be done by applying at the family court. There's a lot of cases like that going on now, and that is asking the court to give them some type of discipline they didn't get, which they're going to need to work, they're going to have to abide by, because the court is not going to play. So, for instance, if they said you're going to be off the streets at a certain time and be given a curfew, you're going to have to abide by that, because then the police can come and take you to juvie hall and stuff like that. So that's called the PINS program. If you need that, you need to look into how you can get that, but make sure you're doing the right thing, because your child will be supervised by the state courts, New York State courts, once that is done. All right, so be very careful of that. When you do proceed, it has to be serious, because they're not going to play, because the discipline wasn't given at home, and maybe it was, but the children don't take responsibility in believing that you would push as far as making sure that you control them, then the courts will have to do it. All right, so make sure that you know what you're doing if you have to do it yourself, because if your children are forced, there's nothing you can do in family court once they make that decision for you. Now, there's another thing called in camera, which is when a judge wants to speak with your child, either without the parents or without the press, legal guardian, attorneys, or anyone, or the public in private, because sometimes children need that type of privacy from the press to talk, and or witnesses. If they're witnesses, they are going to do better to speak to the judge in their chambers. So that's what in camera means. Their chambers is the judge's office where they reside, and they write their decisions on cases, and stuff like that. It seems to me that these children are comfortable that way instead of the press and the public looking in on their cases. Usually, family court procedures are more private anyway, but in general, in camera can in the family court mean that they want to talk to the child specifically by themselves without the parent, maybe with the attorney. It depends. This case may be a neglect or an abuse case. Then the child will need to see if the judge orders that, then that's what it's going to be. The child is going to be questioned to see if the child's parents are abusing them or some relative sexually, physically, mentally, whatever the case may be. This is serious. So then the judge will order in camera. In family court, outside of family court, it's different. For in camera, it's for public and the press not to be inside. Family court procedures is more private, so therefore this is not public record for underage children or anything. This is private information that's not given to the public. So the public and the press is not allowed in. So basically, when they use in camera in family court, it's to find out from the child what is going on in their home, just for their protection and the best interest of the child. This child will be given a legal guardian, a law guardian. Everyone is assigned one once you go to the family court, once the case gets there. And they're called GALs. Um, and I know what it means, guardian ad litem. Yeah, guardian ad litem, GALs. And they're assigned even for adults outside of family court. But in this tape that I'm doing now, because they're assigned for adults as well in surrogate court. But in this case, these are children law guardians to protect and have the best interest for the child. Once assigned by the judge, if the judge assigns one to a child, is to thoroughly check on them and they're making sure that these children are taken care of, whether they're in foster care or at home with their biological parents. It's required to have a law guardian if that case is required to insist by the judge that there be one to watch over the child's best interests. So basically, that's all I wanted to say in all of this. Yeah, basically, that's the basics in family court procedures and things that happen inside. Just remember when you're writing a plea that you do it to effectively. If you can't spell, that's okay and stuff like that. But if you can't read or write, please have someone come in to do it for you or hire an attorney if you can afford one. But you don't have to have legalese if you're pro se. You're not an attorney. They expect you to make mistakes. You just got to know which venue you belong at. That's the jurisdiction. And if it's not that jurisdiction, they're not going to put it on the calendar for you. You're going to have to find it, or they can. Sometimes they'll be able to tell you where it is. Not all the time. I can't speak for every court, but you need to know if you reside in this county. That's usually where it is. All right. So I wish everyone a lot of luck on that. If you are proceeding with this family court procedure and you need more information, you can email me or comment down if I haven't answered something that you want an answer from. I will be glad to get back to you. You can put it below the comments. You can email me. It's on my channel also. I will answer you. So don't forget to like, share, and subscribe um, so that this can go viral and my shows could be heard by people in need of help in other areas and whatever, or to talk. Like tomorrow, I'll be live here in DR with My Truth Real Talk at 3 o'clock here on YouTube, and that will be on Boundaries Part 2. I'll let you know what that's about. Yeah, it's with your employer, your workplace, setting up boundaries, Part 2. You can go back and look at my old last week's tape, and that was Boundaries Part 1 with family, friends, setting up boundaries with family and friends. But this one is also nice because it's setting up boundaries with your employers and co-workers, which should be nice. I would like to hear your opinion, so please come and join me so you can talk live with me and we can interact together. All right, so thanks again. I'll see you there tomorrow, Saturday at 3 o'clock live in DR, the Dominican Republic. Ciao now. Show me how.